Yeah, Baba, it's Nii.
Hello, Temo femo yo temi pe mo femo kan bagmene ni femo oyi wala don wa ake ofebe ni mene nwe wo ba na stand gba ngbeji ni tete obo obi ashon ni tete TV jino ni okwo ne engon na wa de ncha ake mene nwe wasa wo pe ko ye shiba mi bo mo de ni oja ni femo ni oke ha me ni ameba fita wo yi ye shiba mi bo mo de nkaji gbine jigbi kenklen ni mo ko ke video na send bo masumo ake oba subscribe yami ami continue ni ya agwen ko ona boni nchon keji oyejomoko ni osumo no chon ye ishiba mi bomode ni any blofo cho le comment section there ke ojomo chon mo awojeme ikan yo no fe no ni ake wojeme oyi wala don wa bomode no jani fe mo moko kiyan bobon bomode ni okiyan moko onu nwo woku ya no neda ochile mi keje ba aka ye Sunday biami jo Saturday biami ni wo fe wo live show senke bo ake gamanche sanjine update ko eba ni masumoni nke habo no ewo kenye ba aka ye nyeme ni nyekwe nye video ni upload there. It was an old interview ni watch Henry ayi ado eke Nii Yaote Oto gan Paramount Studio Djasetse ekele fe ona boni ni yo in trouble. It's very very old. She ni neke no ninga bo ba discuss ne jebo no ewo ni inte ni in corner ke old audio ni in try habo koni sort of set the stage for no ni wo ba discuss mene because ye audio mi keji obotu oba na ke watch Nii Yaote Oto gan egba from their perspective from their perspective ni bi ni te no ye Djasetse to ke gamanche womo sanjini eba yese mi nke ni bi efe egba le esani from le a perspective in Yeshua kekeji obo the other side unto ame hu ame ya me perspective na me ba suma ke mini ame present ke habo ona boni ni yo so many no dey wodi ntwa na kan audio habo there has been a very serious update ni nojino ni wo ba discuss now keji ole ni obo audio tuye ke ko ba join we cheko ni gamanche sanjine o foko se nyemo ojogban alo show se ko me ni fe ye gamanche sanjina ye ekole okweko no ewo ole moni poten ni ji watch Nii Yaote Oto gan briefly watch Nii Yaote Oto gan leji kan Djasetse ni eto watch ni adama lache watch Nii Yaote Oto gan leji Djasetse ni eto watch ni adama lache now Djasetse na yo be kema kebwe anukwale ni yo minji ake watch komehu kele impele watch ni achole doctor ni tetekwe ye doctor ni tetekwe susumo miye je watch Nii Yaote Oto gan ji Djasetse le watch ni doctor tetekwe le ji Djasetse ni le eto ni teko chulu ni ji enyo ona boni ni yo so ye le susumo miye nuchumo ni watch Nii Yaote Oto gan etue esa na yo awo mi otie mi nji ake eto ni adamalache ni adamalache ne eto esa ni ayo no wa wo mi ejake le doctor tetekwe le ji kan Djasetse ni manche neto ji ni teko chulu so ye le susumo mi ke meni nyese meni support ole ame susumo mi ni teko chulu ni eto le ji moni afemi ni esani akele achuni ake manche once again doctor dabi j doctor ni kekemi Nii Yaote Oto gan lewu ye susumo mi le ji Djasetse ni acho gbepapa no afe kusumi fe ale ni aketole ni woketi le eto manche kwe lewu le manche le ji moni esani eye gano ake gamanche koni echuni ake gamanche ne wo tumobeni nko da ni gamanche sanjin ke mo ko kebo aka gbena ni mofemu enu shishi ni mofemu ekpene no ake ni teko chulu ni ji enyo alo ni adamalache ni jenyo jigamanche nakamo egba abu anukwale nakensajie anyemiolo agbekona one leg of gamanche saneyelie ji Djasetse sanene the other leg eji manche saneyelie denche ni no hu court regional house of chiefs eko kanjeme ayeko court high court Kumasi ameye sanebi anakete appellate court lewu aye ageme. You understand what I'm saying? So kamoko ke bepi ko ke me kumaka gamanche menyo eke me kuma miefu. It is just a fact. Ona boni ni yo ni until ni wabakpa wo ya male mo wabakpa wo kutumpo fe mo wabakpa wo ya bla wabakpa wo ojotwa wabakpa wo ejemo wabakpa wo shishu mo efe mi ake wabanyele de ke no ona boni ncho ni no ni fio ne ke ni fe mo ne nko obo ake mi betim ni betim bi na kan no ni nsumo ne ba ya no na kan no ni nsumo ni wo ba ya no wo ba follow ni boni cheme ne ni nye wo yin amentaw na meshigen ha wo ni me nsumo ni me ba butterfly che me bibio ne mi se machine kan ga ha me no wo ni ta bia ni da ne mbolo ni fio no ni fio etokowo ganangbe etokowo aka wo nye ne ke no ko ne miolo in this 21st century etokowo no wo ni chuo ne ke no chumo ne boni afia no kwale wa ke me na sana no kwale aka ke wo cheko alo wo nyako nye wo yin na efe yake e ka no kwale chuni wo ba ni mambie ana ameyo se no no wo ni yo susumo mi ke wo kwa ne ke wo chene wo na ke wo ne ke wo chene eyi anu kwale esani mi yi no bi na me ka me ba hia me se ha wo ke yi no konklo me hu ni yo wo se ni wo ba hia wo se ha me esani ke sha me no ni ya no ye wo ten akagadan be bi ane esa ni na kan no ese ya no na kan no esa ni na kan no ya no esani chake mo aba ni na kan chake mo ni minka bo fe wo solio ganan be ko mama papa na ebu ganan no e wa ni wo fio no ko na ni wo fio na yi ni won ke ebu ake keji obilongo to ni te ko chulu camp iye chebu inyebu iye che ni te ko chulu ko belongo to ni adamalache camp isumobo feboni isumo mokoni eye ni te ko chulu camp ko belongo to ni adamalache camp inkabo betim kome ni won twa against ni te ko chulu dabi je na kan no ntu oye bie je na kan no mfi oye bie je na kan ji ito ni nketa bie shinke esani wa ya no kwale no na ehi wakadi shikase wakadi no ni wo ba na se wakadi no ni wo ba na ni wo ba ko tafra che wo ngame ka wo bi ka wo nyeme pe wakadi no se ni wo fe ni phone e ba fite gan fe no e won tu ono ni ntu. You understand what I'm saying? Ni mene nke bo aka Djasetse sane e masa nke bo agbe ko no e wo ni nye ntwa audio ani ntwe aboe ne sex stage e for mene. Now in 2003, watch it. Doctor ni tetekwe ni ehiyo akeleji the legitimate Djasetse. Ke watch it. Ni tete ashon ni leun leji gan senche alo osiayini ameke Nii Yaote Oto te court ake Nii Yaote Oto eche court yin atoa ake court woleshi alo awoleshi ake ekache Djasetse ni ekachu ni Djasetse tuo shife se Nii Yaote Oto ebotwe ni ya no ni eche Djasetse ni ya no ni echu Djasetse nuchumo newa no ni blafo chole contempt esani court ha eko amole koni awoleshi ake ekache Djasetse don ni echu Djasetse nuchumo. This is 2023. Now sani ete court wa mene ni watashi ne judge ni akesani hale ne ye eke ruling eba. Now bi amini mi record video ne ili ake ruling ni ekeba a appeal ye eku appeal ye eko inle. Now, ken fe video na ta ni se mi. Appeal ye mani ona ole no ni akeshi amontone ni watashi ne boni jeje e buasane ye no jino ni nke ba habwe mini jino ni jeje e ke ani jeje e ke lele ake woche Nii Yaote Oto gan eche ko to eyin ato a ani no ni akela ake kafe ani jeje e na ake lele ya no ni efe ni no ewe sani contempt amole lo alo mini jino ni jeje e ke alo jeje e ke dabi esa ni contempt mo woche Nii Yaote Oto gan efe konoko ni esa na efio echako egbe ko na esa na echo echu ko nuchu moko ni esa ni echu ani na kenjeje eke ya waboti ami ko ni wakania no ni ruling eke ni wabotwe. Now ruling on motion on notice for committal for contempt. So tumoboni nke ebwe na kanji no ni ebane. So nya waboti ami ni wakandi ni wakwa no ni ake. Eke the applicants be achon Dr. Tetekwe ni tete achon brought this motion for an order committing the respondent for contempt on the following grounds. So achon no gwake Dr. Nii Tetekwe wache ni tete achon ni jenumo ameke Dr. ameke Nii Yaote Oto gan bako tuwe ake contempt amole mine woni ameke contempt amole mine no amedumo na ameke contempt amole no jeje ba ake wo no ni woni amekele ba ake contempt amole. Eke 1, that the respondent has failed, refused, and or neglected to comply with the ruling and orders of the Traditional Council in suit number GTC J65 2009 entitled Nii Tetekwe II and 6 others versus Nii Yaote Oto and 8 others, and suit number GTC/J66/16 entitled Nii Yaote II versus Nii Yaote Oto, thereby bringing the authority and administration of justice of the Traditional Council into disrepute. Mine no amendo ame chono kwake wache Nii Yaote Oto she ke blo ni Traditional Council eke ngweno ye lawsuit ni akete in 2009 ni ichoni kanoji ake Nii Tetekwe and 6 others versus Nii Yaote Oto and 8 others. Ke another one in 2016 niji ni ajimankese niji enyo ke Nii Yaote Oto naka lawsuit na akete Traditional Council kote kela ke bona ke Traditional Council am a judicial committee. Now judicial committee and your is a quasi court, if I should put it. It's a quasi court. So they have the ability under the Chieftaincy Act. Now, so court here kelake le Nii Yaote Oto eka chuni bi kome alo eka fe ni bi kome all order ame ba chon wo order ni jibu na tribunal maka ne je memabo shi ya me susu mo miye no ni judicial committee ye Traditional Council ke Nii Yaote Oto ke fe ebu nakai no ona bonicho no number 1. Number 2, that the respondent continues to interfere with the functions of the office of the Paramount Stool Djasetse in flagrant breach and or disregard of the ruling and orders of the Traditional Council in suit number GTC/J65/2009 entitled Nii Tetekwe II and 6 others versus Yaote Oto and 8 others in suit number GTC/J6/16 entitled Nii Yaote II versus Nii Yaote Oto. So ake echo we tumoboni nkeba ke lawyer say na ka repeat go okwe no one salo duba no chole nege no keke ball perjury ba mobo once again no your number 1 no I repeat go ake once again ya nege suits enyo na efe mi the judicial committee ni your the Traditional Council ameke ni bi come fon Nii Yaote Oto no ake kafe ni ya mesusu momie Nii Yaote Oto ya no ni efe na kan ni biolo no ewo esani contempt afe mini amole. Now number 3, that the respondent bobi etwe continues to hold himself out as paramount to Djasetse in flagrant breach and or disregard of the ruling and orders of the Traditional Council in suit number GTC/J65/2009 entitled Nii Tetekwe II and 6 orders versus Yaote Oto and 8 orders in suit number GTC/J66/16 entitled Nii Ajemankese II versus Nii Yaote Oto. Lawyer said I may trump up a lot of charges. Charge come na abanya fail come abanya abak me ga fail to moteti ego ichwe akami. So bi ana make ewo no ni number 3 you are ambanya me you 1 eke 2 no yi ameke mini Nii Yaote Oto ya no ni che Djasetse olo ni ya no ni fe ni ake Djasetse olo ni neke lawsuits ne in 2009 ke 2016 ne ekela ke ekafe na kainoko na kanjino ni amenke mine woni esani Nii Yaote Oto ya no ne che ya ke leji Djasetse olo mino asane ya no ni echun Djasetse ni lawsuits ne ya mesusu momie a order ye jema ke ekafe na kan down. Number 4, that the respondent continuously interferes in the role which otherwise is the preserve of the paramount stool Djasetse in flagrant breach and or disregard of the ruling and orders of the Traditional Council in suit number, once again I repeat the same suit number said on okay wacha Nii Yaote Oto ya no ne chuo nuchumo ni Djasetse tuo meanwhile awoleshi ye Traditional Council ake ekaya no ne fe na kainoko. You understand what I'm saying? So I mean kake wache Nii Yaote Oto na kan nuchumo jela asanechu aye Djasetse ni asanechu ni wache Nii Yaote Oto ya no ni echu na kan nuchumo ni neke lawsuits enyo ne na amekeba a order le ye miake ekachu na kan nuchumo ne wo minewo ne ya no ne echu na kan nuchumo fe mingbla mo baba kayo tui obabia ni ni tetekwe Nii Yaote Oto we wache Nii Yaote Oto we mino na akela aka mingbla mo fe baba kafa wonu afufue oba na no fe no. Now awo boje to so bia na wona no ne ewo ni ameke case ake I hold Nii Yaote Oto in contempt ake ye amesusu momie judicial committee ye order say ka ruling ni ya amesusu momie amena in 2016 na kaino wache Nii Yaote Oto ke chuuni into obeni nke abwe the judicial committee of the Traditional Council is a quasi judicial system. It's a quasi court technically. Ona bonincho no wona metashi to mo judge na me bo sane to na me yo sane ke no fe no. They have that authority based on the Chieftaincy Act ni amebanye amechu na kani. Now onake ache 2009 ke 2016 amabo background there. Now the first lawsuit ni ona GTC Traditional Council Judicial Committee 5 2009 no GTC/J65/2009 wache Nii Tetekwe ke me pa ko me fite ameke wache Nii Yaote Oto ke lenwe won bi te Traditional Council ake a stop Nii Yaote Oto ake ekachu Djasetse nuchumo mi abo background no G2000 lawsuit enyo ni o na. Now somewhere around 2010 August aye sani ata ayeko she order je Traditional Council Judicial Committee ke ba ke Nii Yaote Oto eka ya no ni echuni ake Djasetse until ni abaye sani eta so na kan order once again echo mo ni Djasetse order ni je Traditional Council Judicial Committee eneba in 9th August 2010 echo mo ni Djasetse shimon eke wache Nii Yaote Oto ke ekachuni ake Djasetse until ni ame Traditional Council Judicial Committee eni yo jame ba tasane no koni ame cho mo ni potem ni Djasetse keka agbene moni abaye abo keka ofemini keka oteno keka ochuni no jinoni na kan order ke so call no na ameke order ni ebu order alo a disregard order no ni order ke ni 9th August 2010. Now sani ekashia kata 2016. Now 2016 judgment ba in favor of Nii Yaote Oto. Judgment any ba a judgment it was a default judgment, meaning ake Nii Yaote Oto gan ame ba different ame case because both way ame challenge both way both way ame challenge the jurisdiction of the judicial committee traditional council ni amebanye ameye na kansanie ye Nii Yaote Oto gan ke lawyer foi ke wonche ni nye se na kansanie gan traditional council amebe ewale na sani ameta na kansanie no ewo na kansanie ameka amewo mi don ni ameya don ona bonincho, and of course ka ke sanite court ni oya ni oba ajo na abana default judgment efemini against the bo she miss money no shishi no ni I'm in court in 2016 eje no koni Nii Yaote Oto game amete na ma present a case ni akwe na akwa me evidence na me ke ba fe ni akwe Dr. Nii Yaote Oto evidence de ke ba fe na ke Dr. Nii Yaote Oto ye evidence wa no wa yesani hale dabi. It was a default judgment against Nii Yaote Oto gan ni Nii Yaote Oto gan ya court to ke lawyer fo ame ya na kansani don ja ke ya me susumomie traditional council be wale na make you na kansani no wa me for me I'm a file ni bi. You understand what I'm saying? So no one I'm in court in a judgment in 2016 from the gan traditional council. I hope I can onu mingbla moneshi. Now I'm a channel in the affidavit in support of the application for committal of contempt sworn to by the first applicant, Niji Dr. Tetekwe, no ne swear with the consent of the second applicant, Niji Nii Yaote Ashon Nije Nomo. First applicant stated that he is the Djasetse of the Gan Paramount stool, and thus the principal kingmaker of the stool, whilst the second applicant is the Senche, stool father of the Gan Paramount stool. So Dr. Tetekwe chono kwake le eji Djasetse ni lepe yogbena ni ebato manche ni wache Nii Yaote Ashon Nije Nomo lenweke le eji Gan fe Senche no juno ni paragraph na ni kandie eyamboeke ani wachano. It is the contention of the applicants that an order of interlocutory injunction in pseudoma JTC J65 2009 on 9th August 2010 restrained the respondent from holding himself out as the Djasetse to moboning bla mi chobo bi aneno ake in 2010 traditional council ke wache Nii Yaote Oto gan ke eka hold itself ake le Djasetse until now ba yesani ata na kan sani echo mo ni Djasetse. Don't get it twisted. No kake in 2010 to ake Nii Yaote Dr. Tetekwe Djasetse dabi je na kanke ake Nii Yaote Oto gan ake wache Nii Tetekwe le ke sani eti no wana ye ko sani ake Nii Yaote Oto gan ake ekache Djasetse na echu Djasetse ni ke ata bia mi ni aba yesani afa mini ata ni nke bu ake na kan no Nii Yaote Oto gan eke chuni because eke lawyer say ameke gan traditional council amebe na kan ewale na sani ameye na kan sandi ona boni nie yo na kan. Now they maintain that despite the subsistence of the order of interlocutory injunction, the respondent holding himself as Djasetse on 11 June 2011 purportedly installed one Judge Taki Abia as Gamanche under the name Nii Taki Adamalache II. Again, the applicants said on 8th February 2018, the respondent, in spite of an order of perpetual injunction made against him, continued to hold himself as Gan Djasetse. And though the respondent has been aware of the said orders against him, and even filed an application to set aside the judgment of 8th February 2018 by the Judicial Committee of the Traditional Council, Accra, and same was struck out for non-compliance, yet the respondent continuing to act in flagrant defiance of the orders of the said traditional council. So I mean chono kwake ni akeneke order na eba still watch Nii Yaote Oto ga ya no ni echun eni ake leji ga Djasetse ni ya no ni eche ake leji ga Djasetse to the extent ake eto moko ni achole George Taki Abia ni ake manche ni esengbe bachon ni Taki Adamalache June of 2011 ona boni chon ake ahale order in 2010 si 2010 na ale na kan order ake eka fe na kan no tata bia mi na ba yesane ebo tue ni eto moko ni achole George Taki Abia ake gamanche ni wafe wolele ake ni Taki Adama lache ni jenyo eko nwe in 2018 wache Nii Yaote Oto ga eliake neke order na no eye ni apply kete judicial committee ni afemini awo na kan order chafo shimon ni kete la application ni kete awo chafo nke abo ake now Nii Yaote Oto ga because of BNA wa magbla mi machombo Nii Yaote Oto ga I'm a lawyer to Mobeni Nkebo Bright Akwete at the time, a lawyer. A file motion against challenging the jurisdiction of the Judicial Committee, a greater traditional council number yesanie. Nakaino traditional council be a way chafu. I'm a keda anya challenge naka ame wale ame ye wale na ame ta naka insanie no juno na ame nkebo ake asset naka motion aside there. Now anyway no. The applicants maintain that the respondent's conduct is willful disobedience of the orders of the Judicial Committee of the Traditional Council Accra, which is an affront and interference in the administration of justice and due process of law. Ake ni wache Nii Yaote Oto ga ete no ne chu neke nuchumo ebe eche Judicial Committee ni your Traditional Council eche amenyi atwa ni ebu mla ke nuchumo ni neke Judicial Committee ni your Traditional Council mlak mo legbe ake chue wache Nii Yaote Oto ga ebu na kan nichumo ni eche na kan order ke Judicial Committee yin efe atwa. It is therefore the prayer of the applicants that the respondent be committed for contempt. No ewo nekede bi na efe na me wi ake wache Nii Yaote Oto ga efe contempt amole kota yosi ake lele eche amenyi atwa no ewo esani mla efemini kele aye. Now mereji na jiemo ni wache Nii Yaote Oto ga ke a lawyer for amekeba. The respondent opposed the application for contempt. According to the respondent, during the reign of Nii Amugi, the then Djasetse known as Nii Kwaku Niri predeceased the then Djasetse Nii Amugi, who died in 2004. There was therefore the need to first install a Djasetse to replace Nii Kwaku Niri so that the Djasetse would recognize the burial of the late Nii Amugi. So, watch Nii Yaote Oto ga ena jemo no ejeshishiem kenkle no na ewe ejiake eke Djasetse ni no mi eyo ye Nii Amugi ebeamie achole Nii Kwaku Niri ni le egbo before Nii Amugi go ni akeke manche gbo esani ana Djasetse ni edomoshi ni afule koni ato gamanche konklo no ewo no we balake besane femini ata Djasetse because wache Nii Amugi ebiami na egbo Djasetse egbo mo niji Nii Kwaku Niri egbo mo ona boni ncho no we besana na Djasetse koni ekwele wache Nii Amugi efumi dani agbene ne ke Djasetse ne ekwe mancheni abawo ne ba ye Nii Amugi se lewu etomi ona boni ni yo. So it is the case of the respondent that the justice tool is one which is ascended to on rotational basis among the four royal houses, i.e. Amugiwe, Tekochuluwe, Takikomiwe, and Abola Piamiwe. He said it was the turn of Amugiwe to nominate candidates for the then vacant Djasetse tool. So wache Nii Yaote Oto ga nke lawyer friend chono kwake no ewo Djasetse ka ye shian ye dwe ni ato gamanche ye mie na kan shian ye dwe ameno na meto Djasetse Miniji neke shiane amugiwe deko chuluwe kaki komewe kabola piamiwe neke shiane edwane na atuwa gamanche yemie neke shiane edwane no ni ametuo Djasetse shimon yenekan biamie eshe amugiwe no amugiwe no ni ame bato Djasetse neke shiane edwane keji ato Djase yemie awu ekome na edumo ame na ni lefi o Djasetse bona boni ne yo so Djase aye council aye Djase council ni Djase council emiye awu ekome eke edumo ame ye eke lefi Djasetse ye na kan no miye na kan be ame esha amugiwe no ni ame bato moni ba aye Djasetse. The stool having been vacant and the late Nii Amugi remained unburied, the respondent stated that he was nominated and selected to ascend the Djase stool. Ake ni tumobeni nkebu wache ni kweku ni rine egbo ni abani di Djasetse ni sane edumoshi ni ato wache ni Amugi ne chonse ne balake bele aseletile ni akelake bele eba ye najian kone edumoshi ni echon Djasetse. The respondent stated that he was nominated and selected to ascend the Djase stool. Thereafter, as chief mourner, his stool name was used on the late Gamanche's funeral program, and he was the funeral coordinator and coordinated all the funeral activities, and no one challenged him. Ake, yana kan biya mi no ni atole. Ake ebaye Djasetse. Afele funeral coordinator. Kenye kaye. That is one of the points. Ni the other side there. I'm for you mwake Nii Yaote Oto edumoshi ake funeral coordinator ni ekefun Nii Amugi she edumoshi ake Djasetse. No Nii Yaote Oto chono kwake dabi edumoshi just as a mere funeral coordinator. She edumoshi ake Djasetse because keji okwa program line up mi fe I use we sing be Nii Yaote Oto niji enyo ayusu ona gbe ko na Emmanuel eminije woche Emmanuel Yaate ona ona ni agma Emmanuel Yaate ye neke Nii Amugi egbele enife mo mi alona correspondence ko kla na oba na a private name yemi shimon correspondence fe ni oba na ke esengbe ake Djasetse no jino ni ake wo jian mi fe ni chuan ke ya na kan bia mi to ayosele ake Djasetse obana ko kwani bi efe Nii Yaote Oto ni jenyo Nii Yaote Oto ni jenyo dani wa afele coordinator lele mi de wa afele coordinator efe ma kan gbla mi ye bi omo chima sama gbla mi e kon ke ale no kwako na kan video afe woche Nii Yaote Oto coordinator ake alo eja ake I set up various committees bi gamancha ya la femo oli ake ni wuluni wache Nii Amugi gbomo wuluni no taflache le yala femo etumo taflache wo shiante ngbonjo ni afunle no I set up financial committee, I set up planning committee, I set up neke committee, I set up neke committees no neke committees ne fe ka me tu aminu tumo esana na moko ne dumona ne fe kome no ji coordinator ni awe ni ake woche Nii Yaote Oto in private life he has a very good experience. It was chief director. You understand what I'm saying? So personally, I can experience any there is no better person ni eba coordinate neke committees than le Djasetse ni in a private life where he has more than the needed experience ne eba dumo nakai noko na. You understand what I'm saying? Nwewoni obana Nii Yaote Oto coordinator. She no ake I feel a coordinator just for coordinator's sake. You understand what I'm saying? Now, in his capacity, chono kwa ke na kan bia mi une echu ne ke no ko ne fe moko kwe challenge ile moko kwe ka ke Djasetse jibo ne wo obey gbani ofun Nii Amugi na kan jino ni make the last part of that paragraph ni kan abwe. In his capacity as the Djasetse, the respondent stated that he removed the traditional wristlets or wristbands of the late Nii Amugi II prior to his burial in accordance with the customs, traditions, and usages of the Gans of the people of Gan or Gan people. And he performed that singular traditional and customary function without any challenge from him. Okay, once again, aka ni mo fe mo na kan bia me yosi aka leji Djasetse ni wache ni amugi gboe afili ni wache ni amugi fu gboe leji mo ni efu afili leji mo ni enyi afili moko e challenge ile because ya gan kusumi ye ka gan ni fe mo mi Djasetse leji mo ni yo egbe ni na afili ne e ba bedin no na kan bia me ni wache ni amugi gboe afili aka ni mo fe mo yosi ole wache Nii Yaote Oto gan aka leji Djasetse afili le jimoni ebajede ni le jimoni enye ni mokomoko e challenge ile mokomoko e bu koi ngma affiliate mi no e affiliate be je bo Djasetse ka affiliate ba no kan Djasetse mokomoko efemini ewe nakan. The respondent also contended that he discharged his other duties as the paramount to Djasetse, including leading the vetting screening process to install a successor to the late Nii Amugi II, being Boni King Taki Adamalache as the new Gamanche, and formally introduced him to the traditional council. Akani le no Djasetse ni edomoshi ni efuni Amugi le no ni beshe ake asani atao moni baye Gamanche na jalo Gamanche konkloe nuni blofo chole vetting ake nuni abake ashami many potentially ambanya me Gamanche ake me ba na sha na kan me abia me dansanji akwa me shishi akwa me se nuchumo na mechu dia me suban yo ten ngba me hindan ani taflache onyo wo moko ni taflache ajudan so akwa na me fe ka bi me na sanji le ake gan Djasetse wache Nii Yaote Oto gan le edumoshi na echu na kan ni chumo me ni ba ake aveti amena me Gamanche le wache Nii Yaote Oto gan le du moshinechu mokomoko e challenge le including Nii Teko Chulu ni jenyo Nii Teko Chulu ni jenyo at the time yose wache Nii Yaote Oto gan ake gan Djasetse nwewe ke ete ni wache Nii Yaote Oto gan veti le ona ene me ke wo boy famomo ni wo boy wiemo e ka ba ke wo ye team A biana aga achobi Prince George na ga chom ko te Facebook na ga me go me chomi George's son Prince George shi na kan bia mi wache Nii Teko Chulu ni jenyo yose Nii Yaote Oto gan akele ji gan Djasetse ne ke ete ni aveti le je ni tete ko eveti le garangbe nye bu ato ojo gba ene meke won yue ni efe otumo inu me ko ma shishi na kan bia mi wache Nii Teko Chulu ni jenyo yose ake Nii Yaote Oto gan ni jenyo ji gan Djasetse ni eke awe shishi na vetile na bile dansanji mini we sane ye Gamanche mini wa sana fele Gamanche imeje nuchumo nechu resume ke ni bi fe ke ha na akwa fe mi je ni tetekwe jimo ni veti Nii Teko Chulu ni jenyo nye bu ami to ojo gba moni veti Nii Teko Chulu ni jenyo ji Nii Yaote Oto gan so te fi ote ni moko veti obo oko ya a force ibo agbabo by force shibole nto oko eti aka veti bo ni mo veti obo ni ke veti bo semiatan no ba ga ka ojele Djasetse don because na veti e agehabo na agehani adama lache akele jimoni esani eye Gamanche once again Nii Yaote Oto gwancho no kwake nege no fe moko e challenge yi Nii Teko Chulu e challenge yake Nii Yaote Oto gan egbe ne veti ole e challenge now ni ni adama lache ni jenyo ake Gamanche ni ekele unya ha gan traditional council. He also indicated that there have been 2 subsequent arbitrations which went in his favor as the Djasetse, and that he has not been personally served with any notice of entry of any alleged default judgment. The respondent, therefore, is of the view that the instant application be dismissed. Now, onune chitake there were 2 arbitrations. Military na kan arbitration say fair Djasetse. Biamini abon Djasetse pelemo. In 2006 the Gandangbe Council no lene no. Ame kashi ni ame kwesane mi. Ni ame kwesane mi enka ne fen yabo ebi several times. Enka ne fen yabo ebi several times. So many videos e ba jeke. Noti arbitration kenkle na afe in 2006. Ni afe na kan arbitration ame ya wo mi ake. Nii Yaote Oto gan le eya no ni etuni ake Djasetse. Shimon wache ni tetekwe abanya fe la mugiwe weku nupa noji recommendations ni Gandangbe Council ekeba. Semi we gan traditional council ame fe arbitration na ame fe arbitration no jino na fe ye ni otintoshia ni sempeshia nyekayo ni adoto tinto le shia fe na arbitration ye so ko ona akeshi ake video kon select nka ke select video kon circulate ni na kan video e mi onu ni mi de nchempa impa mi bodo manye to yo ten obi nu ego ntu egbo na mbe ego no ni wache ni adote otinto ekake ele ake Djasetse saneko ye na kan no je anukwale ni wache ni adote otinto ele pepe pa kega Djasetse saneye arbitration komie le shia ayeye na ayeye shia mini gbe pa mo ameba abagbe pa mo ake wache Nii Yaote Oto gan le eya no ni etuni ake Djasetse. So 2 arbitrations say nyone fe ni wache Nii Yaote Oto gan we eji anukwale document nke chombo before ni fe awe in his favor ake le eya no nke komie wache ni adote otinto le eshia ayeye no na kan video no na ni wache ni otinto ke o ele ake Djasetse saneye ke ona le ye enemy no na le na kan no na ewe ejeme je anukwale ni ele ake wache ni otinto ele ake Djasetse saneye arbitration komie le eshia ayeye no say me ni ayata ni ake wache Nii Yaote Oto ga eya no ni etuni ake Djasetse ni wache numo gba me ni ji sakuma wulomo ke numo akwa mi nsan ni ji na ewulomo ame ani ame kankita ye jeme ye bu atu odogba Gandangbe ye bu atu odogba ani nke ne kan ne fiam ana ame kankita ye jeme mokomi le eke aboti atwoni ni mokomi eke gbanten twoni so aye abotia na aye gbanten can I am a respective wajinye ni ani ame kankita ye jama ake ame mokomi fe wache Nii Yaote Oto gan ake Djasetse ni ame mancha komi fe mancha ni wache Nii Yaote Oto gan ke ba wu ame den ake moni etola ake mancha ni ona wulo mo enyo ni nye wenye ke yue ne keke ni tete nchok ke gbonjo aye gbanten kabotia mo fe mo no wo sumo na afo ejemi na ke yenpa na me kankita ke Nii Yaote Oto gan niji Djasetse le peji mo ni ame ba yo si ake Djasetse ni manche ni ame ke ba chu ni efe manche ko fe mo ni Nii Yaote Oto gan ke ba wu ame di ake manche ni to ni numu akwa mi san ke numu ogban mi saguma wulomo ke na ewulomo shina me wo ye ni otinto shian ni ke mba tabi eni bia ke ma ba e ka ba ke nchogbe ke gbonjo ene wo wache Nii Yaote Oto gan e ke awo contempt na ke ba na chafu. Now in their supplementary affidavit in support, the applicants denied the allegations by the respondent in his affidavit in opposition, stating that the respondent was only appointed as acting paramount to Djasetse on 21st September 2008 and subsequently removed on 30th November 2010. That cannot be true. I mean, maybe Afuniamugi. So take your 10 in 2008 and I feel like acting Djasetse in 2008. Anyways. ni ajiele jeme 30th November 2010. So naka I'm provide the date ni ame chono kwake afe wache Nii Yaote Oto ga be bia ne Dr. Tetekwe ke ni teta show ma me yu ne akeda bi akabo wache Nii Yaote Oto ga to ni bia ne UFN Shimon afele acting Djasetse in 2008 no mi bi ba ke ka afele acting Djasetse in 2000 no maybe wache ni amugigu ni maybe afunle wache ni amugi maybe go ni maybe afunle na afio wache Nii Yaote Oto ga 21st September 2008 na afio le Djasetse maybe wache ni amugigu ni maybe afunle ni aye neke acting ne hu ye de November 30th 2010 I may provide evidence mo exhibits ni about inkabofen o leakelo ene more. Let me be clear that the factors as recounted do not mean that this court has jurisdiction to determine who is or who is not the Djasetse of the paramountcy. Once again, court tem fail clear ake le ebe jurisdiction nyebu atwe. Court tem fail clear ake ebe ewale alone na kan ewale ni eba atwo moni poten ni Djasetse le court mla e clothly kole we na kan ewale shimo, but to determine whether or not the respondent has willfully and intentionally usurped the judicial power of the court and thereby brought the administration of justice into disrepute, utter disregard, and derision by his conduct. Shimo, badeba kwake anilele ake Nii Yaote Oto gam eche kote yin atwa ni ewo kote emujilo ni ebu kote lo once again jeje fele klake sanene ne ba ye eye ne ba tun mo ni Djasetse je no e ba ye shi akeba ni ekwa aka ni lele wache Nii Yaote Oto gam eche kote yin atwa ni ewo kote emujilo no jino ni e ba kwe. Now, it is well established that any conduct which tends to bring the authority and administration of the law into dispute or to interfere with any pending litigation is contempt of court. Ni chwake no fe no ni obafe ni eke court yue moy alo court shimwo pa gbe alo e ba challenge court to e wale na kan mo echon no kwa kebe oche court yin atwa ni wo abanye ni afemi ni ambobo ke contempt. So I'm a kind of straight ene me fe jeje ball a site authorities ne site ne ke define ke contempt ne no ni maka na e so bi engbla mi maya lo straight. The Black's Law Dictionary 9th edition defines contempt as conduct that defines the authority or dignity of a court or legislature. Because such conduct interferes with the administration of justice, it is punishable, usually by fine or imprisonment. In Republic versus Boatin and Odro ex parte Ajenim Boatin 2009 XCGLR 154, the Supreme Court defined contempt of court to be that a person commits contempt and may be committed to prison for willfully disobeying an order of court requiring him to do any act other than the payment of money or abstain from doing some act, and the order sought to be enforced should be unambiguous and must be clearly understood by the parties concerned. The reason is that a court will only punish as contempt a willful breach of a clear court order requiring obedience to its performance. Therefore, disobedience, which is found not to be willful, cannot be punished. Similar decisions of the Supreme Court had earlier been pronounced in cases such as Republic versus Mensambunsu and others. Ex parte Attorney General 1995 to 1996. Number one GLR, I think Ghana Law Review 377. Number 2, Opoku versus Libya France SAS 2012 1 SCGLR 159. The basic elements or ingredients that an applicant has to establish against an alleged contempt law have been well laid in Republic versus Sito 1 ex parte Fojua 2001 to 2002 Supreme Court Ghana Law Review 322, where the Supreme Court stated that there must be a judgment or order requiring the contempt law to do or abstain from doing something. It must be shown that the contempt law knows what precisely he is expected to do or abstain from doing, and it must be shown that he or she failed to comply with the terms of the judgment or order, and that his or her disobedience was willful. The respondent, now, the court authority say it. Now, the respondent has denied that he has willfully disobeyed an interlocutory injunction, exhibit NDKT, that was granted on 9th August 2010, 14 years ago, and questioned what had become of the substantive matter. So, what some of the evidence exhibits what Nii Yaote Oto ikeba chono gwake order kokla be ni ebu na kan order chono gwake ne order ne 14 years ago to no e bi ake 14 years ago to na order me juno ni e ba ye na kan order se na kan sani aye aka quote no quote nka chu na kan nuchu monto na ba ye 14 years so na kan sani aye kolo na kan juno ni amenwie. Now, the respondent also denied having served with any default judgment in suit number GT6/J6616 entitled Nii Ajumankese II versus Nii Yaote Oto. Agbenenwe ake neke default judgment in kebu ake Nii Yaote Oto ke I'm a lawyer say no matter that can time lawyer Bright Akwete a lawyer at the time I may challenge the jurisdiction of the judicial committee and traditional council ni amebaye na kan sane no wa me ya na kan default judgment ne wacha Nii Yaote Oto ke enako default judgment ko ye ko onum shishi eliaka ye sane ko ni ale na kan default judgment against the law. Having denied the allegations against him, the burden is on the applicants to prove beyond reasonable doubt that indeed the respondent willfully breached those orders in exhibits NDKT and NDKT1. This is because an application for contempt is a quasi-criminal relief that is being sought, and by Section 13, Section 1 of the Evidence Act 1975 and RCD 3223, it proves that so biamini wacha Nii Yaote Oto deny yake eliake ana default judgments against le money kesane ba ake wacha Nii Yaote Oto check out to in this case the traditional council here to benake mo la sane prove ake lele amena neke judgment ni ame face ake wacha Nii Yaote Oto ba yosi ake ana neke judgment against le ni ebo to. In any civil or criminal action, the burden of persuasion as to the commission of a party of a crime which is directly in issue requires proof beyond reasonable doubt. Me proof beyond reasonable doubt. Neke judgment in na against what Nii Yaote Oto yawe ake ana naken judgment against the law. It is the submission of counsel for the respondent that the order allegedly given by the Judicial Committee of the Traditional Council as contained in exhibit NDKT, if it was obtained by a motion ex parte, cannot go beyond 10 days. The said order in part reads, Amenchono gwake keji aha na kan order ko lele na kan order esane ya beyond 10 days. Ona bonincho. Now order na ayue order chono go be ake. And upon hearing Nii Tete Kwei the second, for and on behalf of the joint applicants hearing, it is hereby ordered that the first defendant, Yaote Oto, aka Emmanuel Yaote Takiya Boy, so a full name, Emmanuel Yaote, is restrained from holding himself out as the Djasetse. So order now, August 9th, 2010, no account here. Learned counsel further stated that exhibit NDKT1, which was a judgment in default of defense, was also not served on the respondent for the respondent to know exactly what he is being restrained from doing. Order na can default judgment na mechita aka me na judgment echo no ni poteni wacha Nii Yaote Oto ekafe. He said a copy of proof of service of the default judgment could not have been exhibited to prove this situation. Agbenenwe esani shukwe amecho aka lele niti we wacha tete kweme sana amecho aka lele na kan order alone na can default judgment lele sana menya amecho aka akan ha wacha Nii Yaote Oto ni eyose aka akan hale. He then concluded by referring to the respondent's exhibit 6, which I believe is a misnomer. Misnomer misidentification alo o label no go wrongly ni try get exhibit any Nii Yaote Oto gan a quote ye be any wrong one je in trouble since exhibit YOG6 is a letter talking about admission of Nii Yaote Oto II into the Ghana Traditional Council as president, but not on any arbitration. So once again, if I make jam Nii Yaote Oto gan lawyer ni a submit ni bi ekome a misquote ni bi ekome. Make sure I mislabel some of the things. Identify me properly. The exhibit learned counsel for the respondent may be referring to is exhibit YOG8. So yes, YOG6 YOG8 refer to it, which is a report on the arbitration by the Gandangbe Council on the issue of the Traditional Council, which council said it remained unchallenged before the 2016 case, which purportedly resulted in the default judgment. Ake wacha Nii Yaote Oto gan lawyer nchono ko wake neke order ne in 2010 in 2006 ton Gandangbe Council ame tashi ni ame kwesane ne ni ame chomo ni esani eyano ni eye Djasetse ina kaino a challenge na kaino ni Gandangbe Council tashi ni ame kwesane efe na ame ke watche Nii Yaote Oto gan eyano ne chuni ake Djasetse. Mind you, court recognize your arbitrations. Court recognize your arbitration. No waje na arbitration awoni because court recognize your arbitration. Ona bonicho mlagmo ba ke court mo go na sane court mo no ke ya court no ba nyo cho nu pa na tashi onu pa ni amenye fa na melewolomi ni they are of high ni ne ona bonicho na ba nya me tashi na me kwase ne mlagmo ba ke na ke no ya no ni na ke no ke te no na ke te court you are warming. Beja bo prove ake na kai no noko ye no na kai no totomoko ye no esa ni court here. She keji saneba ona ni ache onupai na me ye fa ni ame ye gbena ye society mi aka ametano ni ametano na ame ye na kansane court recognize or court you are warming. So no wani wacha Nii Yaote Oto gan lawyer nchono wake 2006 arbitration ni Gandangbe Council bi etano ametemo kwe challenge ni nakano eke wacha Nii Yaote Oto gan eya no na chuni ake gan Djasetse. Dani 2016 na me ka na default judgment name. It must be observed that by order 50 rule 14, which is subject to sub rule 5 of CI 47, proceedings in an application for contempt cannot commence until the court satisfies itself that the respondent to the application has been served personally, or the person knew or might have been known of the order of the court, especially if the person was present when the order was made. No jeje nchono kwake neke order 50 rule 14 ne chene chono kwake keji before ni court here e ba ta no kwake yesane yake contempt amomokwe esani court anya establish ake lele mo no ni ake cafe ni efe lele mo ya we mo yin kanu mo le aka ke la ke neke no kone e cafe ni eteno ni efe. So jeje once again a site authority name see Hudson v. Hudson 1962 over and me 3 or ER 1056 Republic versus Moffat ex parte allotate 1971 number 2 Ghana Law Review 391. If I get any lawyer for a chom be na cholo. It is to be noted that there is no copy of an application exhibit by the applicants from the Traditional Council upon which exhibit NDKT was obtained. This is necessary since service of exhibit NDKT is being disputed by the respondent, as well as doubts raised concerning how the said exhibit NDKT was obtained. Once again, and the exhibit Traditional Council challenge money Nii Yaote Oto me challenge or beka ka me fe nakan. As regards exhibit NDKT1 in respect of suit number GTC/J66/16, but no jino ni ana neke suit no jino ni ana default judgment there was notice of entry of appearance to the said suit by the lawyer for the respondent, Bright Akwete Esquire, and there was even a notice to raise preliminary legal objection filed on 3rd October 2017 to object the jurisdiction of the Judicial Committee of the Traditional Council to hear the case. So I'm in 2016 case and not default judgment here. No ele jaja ke no kwakele ena no mi ma kele na ke no kote no eja ke ena wolopo ni wache Bright Akwete a filing na kan time ni a challenge the jurisdiction of the Traditional Council na me bata na ke no kono 3rd October 2017 ben ke bo ake no woni ame ya because I'm in challenge na kan jurisdiction. Now after the motion for judgment in default of defense was granted, Exhibit NDKT, the respondent through his lawyer, filed a notice to set aside the default judgment before the Judicial Committee. Once again, default judgment. Lawyer Bright Akwete no a filing Judicial Committee of the Judicial Committee of the Greater Accra Regional House of Chiefs. Now me set aside na ken judgment ni default judgment ni which I need to na the Traditional Council. This, it is clear that Exhibit NDKT1 was duly served on the respondent. Otherwise, there would not have been an attempt by the respondent through his lawyer to set aside the said default judgment. It therefore does not lie in the mouth of the respondent to say that it was never said with the exhibit NDKT1. So once again, Keji wache Nii Yaote Oto ganke lawyer fu eke neke default judgment neke enoko ne amene ne share no na amele jeje ka me pan gbe ja ke kenye le no kwete fi ote ni lawyer a file of motion na set aside neke judgment ne so no jeje ke ka me na kan no be that as it may, the applicants maintain that though an order of perpetual injunction was granted against the respondent in the ruling of the Judicial Committee of the Traditional Council in suit number JT6/J66/16 dated 8 February 2018, the respondent continued to hold himself as the Djasetse. Once again, I'm a chono waka yene me face wache Nii Yaote Oto gan ya no ni tuning ake Djasetse olo ni ya me susu momie ana default judgment against le ya agbene won court order le in 2010 ake ekachuna kanoko. Now it appears that the applicants did not it appears that the applicants did not have any issues with the acts or conduct of the respondent from 2006 until they filed suit number GT6C/J6/16 before the Judicial Committee of the Traditional Council, which gave its ruling on 4th October 2018. So Jaja Nchono kwake ekwano ni femo femie me na me kesane ne bane amen tana me chono kwa 2006 nutu moni wacha Nii Yaote Oto ga etufe amena na agbako yehi egba amena amena totomoko ya kata 2018 dani amena ne ken ruling ne keje Traditional Council jeje ke ene be na pe 2006 enye na kani efe ahun kata bi amini nye file ne ke suit ne in 2016 then nye na judgment in 2018. The applicants especially based the misconduct of the respondent on exhibit NDK3 series, which may be termed press releases by the office of the government at the time, those signed by the respondent. These press releases appear to have taken place in 2020, 2021, 2022, and 2023 respectively. Okay. Nibi ni ameke ba. Ake no chon wache Nii Yaote Oto ga nuchu mwene chu ake ya misusu myesa ne chu eti press releases ni a release from the government office in 2020, 2021, 2022, 2023 no meni wache Nii Yaote Oto ga sign shishi ake leji ga Djasetse. If that is the case, a portion of an earlier ruling by the High Court presided over by a leadership, Novisi Efua Ayene, Mrs. Justice of the High Court, attached to the applicant's supplementary affidavit in support, a marked as Exhibit NDKT8, which was certified on 20th April 2018, reads as follows. Now, amakane noni ayuebe and makabo novice case name. And that the committee accordingly struck out all cases pertaining to the dispute to make way for the amicable settlement of the dispute. It is instructive to note that these depositions was not disputed or challenged by the defendants and applicants hearing. In my respectful opinion, with the dismissal of the dispute by the Judicial Committee of the Traditional Council and the resolution of the dispute as per exhibits YAOTE2 and YAOTE3, the injunctive order was no longer operational. The objections by the defendants are overruled. Now, novice case ne novice case no ba na ka site wa na novice case ne biame ni wacha ni dodun saki ekpene ni ebagme presidency of the Traditional Council e kan wacha ni adamalache etene yasiu. You understand what I'm saying? Now, judge ne tano legi novice efua ayenie neke novice case na court wa. Now, na ken sanie wacha ni adamalache aye hale on technical grounds. Can you kind novice judgment obanake it was purely technical. Some of the things ni ewe ekojiake define ko no ni poten ni esani wacha ni dodun saki at the time acting president of the Traditional Council define ko no ni poten ni esani efe ni ekehe wacha ni adamalache we were no kona different ko anya old against them. Number 2 ake wacha ni adamalache echon no koni chon ake a request no jimi cho a request ake ni dodun saki ashale awomi shimo wacha ni yaote oto ganji moni fe na ken jeje uncho no kwa ke le ni adamalache ne ke sani e ba le echon ake fe na kan ni bimo ni aye no agbenenwe noko yawuna asana file within 6 months wacha ni adamalache tashi na me ana checho for 6 months dani ame file na kan ni so na kan no aye ale na kan mandemos ne ke te court ke mandemos ni ake ni dodu aseki ake tashi ne ba ko de shi jeje yi ale shi na kan judgment mi judge ncho no kwa ke ne ke cases ne fe ona boni ni be ko ba shani ata oni asolve ne ke gandagbe sande ne wo Traditional Council ameka na kan cases fe ame wo fe na ameka ma side ameka fe ma fa amaka na eko, and that the committee accordingly struck out all cases pertaining to the dispute to make way for the amicable settlement of the dispute. So novice ani wa recognize ake neke nibi neni wacha ni tete kwe ke wacha ni tete ashon ka me wonche amenka ke a hold against the wacha ni Yaote Oto gan neke mande mon sande ayose ye mi ake neke cases ne fe ake fe ma fa ona boni chon. It is instructive to know that these depositions was not disputed or challenged by the defendant and applicants therein. Ake neke bi aminisa ne ya ne amete mo ko challenge ake o neke cases ne still ye ni esani ake chuniolo. In my respectful opinion, with the dismissal of the dispute by the Judicial Committee of the Traditional Council and the resolution of the dispute as per exhibit YAO2 OTE2, the injunctive order was no longer operational. The objections by the defendants are overruled. They were able to prove the case is never mind you, because meaning the Traditional Council I'm a fair arbitration ni now, the portion of the ruling quoted above may have been in relation to suit number GJ61917 filed in the High Court General Jurisdiction Accra on 13th November 2017, entitled Nii Yaote Oto II versus Nii Dodu Nsaki III, Dr. Kintekochulu II, Dr. Tetekwe, and mark exhibit NDK2 series and attached to the applicant's affidavit in support of the application for contempt. It is interesting to know that exhibit NDK2 series and the portion of the ruling of the High Court and attached seem to favor the respondent, and these were all exhibited by the applicants. So JJ Nchono Kwake keji ekwe neke exhibits ne court ne ke novice ruling ne portion ne kan de emi nibi ne na me yue ne fe favor ene wache ni tete ko me mo ke bai shi mo ke kwe neke nibi ne fe exhibits ne fe na me ke ba ke ni ke do na me yue ne fe ke bata bi ne favor wache Nii Yaote Oto gamo. It is interesting to note that Exhibit NDKT2 series and a portion of the ruling of the High Court and attached seem to favor the respondent, and these were all exhibited by the applicants. So I'm a moneke exhibits na make ba keneke portion any your novice judgment tell me muni I make a fit here momo favor Nii Yaote Oto gamo. The applicants contended that the respondent was deposed as acting GAN Paramount Stool Djasetse on the 30th day of November 2010 by a statutory declaration, and that the first applicant reinstalled as the GAN Stool Djasetse on 1st May 2012. So I'm chono kwake I'm judge chono kwake. Wacha ni tete kwe men chono kwake wacha Nii Yaote Oto gan akalengma fa akega Djasetse 30th day of November 2010 nile wache ni tete kwe atole ko ake Djasetse in 2012. I do not intend to go into the intricacies of the removal or the appointment of the Djasetse, since this is not within the jurisdiction of this court. Jeje nchono kwake esumone ba bote mi boni achon ni atwo Djasetse alo akpa Djasetse ejake court we ebe waleni ebaye nakainoko. Having said that, it is to be noted that on Saturday, the 14th and 21st March 2015, an arbitration committee held that the respondent is the rightful Djasetse of the GAN Paramount Stool. The court recognized arbitration. She yes, akadima chwake nekeji gbeno na chon na keto Djasetse ke gbeno na chon na ke pa Djasetse ebe wale me nyema chon shimon yade bia mi fe ni nkwe GAN traditional council ameta neke sanene mi ame fe arbitration or enyo Saturday 14th another Saturday ko 21st March 2015 ni ame yose na ame to ake wache Nii Yaote Oto gan le jimoni esani eye Djasetse nke bu ake nega arbitration wache ni otinto e shian fe so ke onana kan video e kon no moko twabo ni onani wache otinto yue mi ake le ake Djasetse ko saneye na kan yue mo je anukwale ni so je jama kan je me kon eke. Having said that, it is to be noted that on Saturday, the 14th and 21st March 2015, an arbitration committee held that the respondent is the rightful Djasetse of the GAN Paramount Stool. The subsequent High Court ruling referred to Supra, like a Supra, no need Akoti before, put the matter to rest when it held that the injunctive order was no longer operational. Judge Novice, one of the reasons say what ni kake neke orders can be ne fe esani accord because I'm a traditional counselor. Be ame ame chu neke arbitration nu chumo pe ni chu aka menu shishiake na kan ni be efense na feminine awo na chafo na me ke gmafa ne wa ye novice ye ruling am impo na kan order kan ni be efen na court ye efen novice ye efe ebu e ka chuni because e ka ye le susu momi ni anye atashi ni afe arbitration na kan no fe eyan don no judge and court ye bi ake. The subsequent High Court ruling referred to Supra put the matter to rest. Ake nakan quotation ni when your novice you put on a matter as to whether there is an order against what Nii Yaote Oto gan can before judgment can be put off to rest. Ake meaning the injunctive order was no longer operational. Biamini the traditional council tashina me fe arbitration na can order a tuni don jeminke manye novice judge leke na kan That being the case, and the said order of the High Court not set aside by a higher court, any subsequent act or conduct by the respondent, from my point of view, cannot be an act of contempt. Ake, ni wanye novisi, wo mi ake, because of naka arbitration, ke shini traditional council try na me tashi, ni amebu, na me ya wo mi ake, wache Nii Yaote Oto gan, yano, ni echu, Djasetse nuchumo. Na can rule yenwe asset ko aside mokoya appeal ko na can rule yen na set aside there benuele le judge ne na wache Nii Yaote Oto gan ni fe mo kula ake chemla ko yin atoa na wache Nii Yaote Oto gan Nii Yaote Oto gan ni chumo ko kula ake mla yin atoa ni chuake ni chumo ni wache Nii Yaote Oto gan because of naka nuchumo naka arbitration ni traditional council efe ewo bobanake naka no poten ewo no kokura be ni wache Nii Yaote Oto gan efe ni esa ni efio because yam la mingbla mo mie bi ameni traditional council tashi ni afe yake abasa na kensanie na me tashi na me sape na ete wolo no pe naka order kan bi na court ame court wo fe naka order kan bi efe don fe wale bemi don novisi judge novisi kena kanton. There is no gainsaying that the fact that the contempt of court being a serious issue, the punishment or any other punishment as prescribed by law undermining the administration of justice must not be used capriciously. Okay, esa ni neke contempt and ne a call like because ka contempt, you know. The Supreme Court in Republic versus High Court Fast Track Division Accra ex parte PPE Limited and Paul Juric Unique Trust Financial Service Limited interested part 2000 stated that the courts should be anxious to contain the power to punish for contempt, which is said to be wide and arbitrary and should be done within the narrowest possible confines in order to safeguard the fundamental constitutional right of the individual to liberty. In such applications, which would deprive the liberty of an individual, actual but not imputed, notice of the specific terms of the orders must be proved. Echoed another authority. Republic versus Beku and others, ex parte, Ajay, 1982 to 1983. It's echo number 2, Cleveland versus Alexandra, 1963, Ghana Law Review 758. In the circumstances of the instant action, I find that the respondent never engaged in any conduct that constituted a breach of the orders of the Judicial Committee of the Greater Accra Traditional Council, especially when the High Court in suit number GJ 1619/17 delivered a ruling on 17th April 2018 to the effect that no injunction order was operational any longer, having regard to the fact that the dispute was dismissed by the Judicial Committee of the Traditional Council following the resolution of the said dispute between the parties. No judge nkake yene me femie ena ni fon kokla ni wache Nii Yaote Oto gan echu ejake I court judge ni wache wonye novisi rule eya wo miake neke odaji ne fe ni wache ni tete kwe ke wache ni tete ashon ke ba ake wache Nii Yaote Oto gan eton neke ni bi ne no bi amini Traditional Council tashi aka me ba ye na kansanie na me tashi na me ye na me fe arbitration na me ke Nii Yaote Oto gan eya no aka chunie tumoboni wonye novice yu ekele kpangbe aka no kometo ani na kan ni bi efe awu achafo because na kan order no nye njeme na aka ke she atashi na ye sani no na kan sani na ye na pene aka Nii Yaote Oto gan eya no na echu enu chuma ake Djasetse na kan order je ni ameba na me kotu ofe fe tuni do eyin do awo fe achafo ni kan Traditional Council nya fe arbitration ni mo fe mo ye awomie be na kan order se fe ebedon no le judge na enwe kake ekena kan no kwan agbe ni twanke wache Nii Yaote Oto gan efe ko efon nuchumo na echu ake Djasetse efe ko efon ya no na echu no ko na stand echu. Therefore, I hold that applicants failed to meet the evidential burden placed on them to satisfy the standard of proof required, which is proof beyond reasonable doubt. This means that the application for committal for contempt fails, and it is hereby dismissed. Signed, His Lordship John Bosco Nabarese, Justice of the High Court. So no judge chono kwake ye na me fam here sane ni woche ni tetekwe ke ni tete ashon ke ba ewo echafun woche Nii Yaote Oto gan efe konoko gbondo nuchumo na echu aka Djasetse gbeka na ka you know pretty much that is how you can interpret it. Nuchumo ni echu aka Djasetse ni ameke wo court emuchi ne che court atwa jeje nke da bi e ka me pangbe woche Nii Yaote Oto gan wo court emuchi ne che court here atwa nuchumo na echu aka Djasetse fe eyegbemi aka esani echu aka traditional council to moboni novice ke wo ame na kesani amemuna na ameye aka woche Nii Yaote Oto gan ya no ni echu ni aka Djasetse. So gara me mi sane keji Nii Yaote Oto gan enuchumo fe na echu aka Djasetse court eke efonko be eshako be echeko court yin atwa ni ewo ko court emuji lawyer fo minute no ni wo ba nye wo court and in some of the cases ni your court and e ba nye wa garame court ke nuchumo ni Nii Yaote Oto gan echu ake Djasetse muji be efe ko no ko form echeko court yin atwa na ewo ko court emuji na ewo contempt ni tete ko ke ni tete ashon ke ba awo achafu. So na kan no je lawyer Jimmy inle ise ambo minute no ni wo ba nye wo koye je ke nuchumo ni woche Nii Yaote Oto gan echuwe ake Djasetse echeko court yin atwa ni ewo ko court emuji no akade me bi sani ake neke no je lawyer Jimmy minute no ni wo ba nye wo koye gamanche sani aye ko atankolo aye mbeji ni tete obobi ashon oyi wala don. Bye bye.
Yeah, baba. Yeah, baba. It's Nii. Them say you want to chop my